Good evening. On behalf of the Rhode Island Young Democrats, the RW Democratic Law Students Association, and the RW Law LGBT Alliance, I welcome you to tonight's event. It's our honor to be here tonight to work with these esteemed panelists and with some great organizations. We'd really like to take this opportunity to extend a special thank you to the Cable Car Cinema, Narragansett Beer for supplying, Pronzi Catering, and Treehouse AV. We thought it was so important to come together tonight over this pressing issue, the future of same-sex marriage in the Ocean State. And to really get some answers as to why Rhode Island has been kind of slow on the uptake in the overall trend in New England. We think we assembled a great panel tonight to answer just those questions. We will begin tonight's discussion with RW Law Professor Courtney Cahill, who will give an overview of the historical and legal perspective, and Representatives Frank Perry and Art Handy, who will give context to the current bill in the House. We ask that you hold questions until the end for the Q&A portion, and we hope that you enjoy the program. Thank you, guys. Than most people think about when they think about the so-called legal case for marriage equality. So, the legal case for marriage equality, some of you might already know this, began in an academic setting nearly 40 years ago in 1970. Two male students from the University of Minnesota's Gay and Lesbian group, one of whom went on to become an attorney, applied for a marriage license in their local clerk's office, where you generally apply for a marriage license. Legend has it that the clerks looked really shocked when this happened and asked one of them, "Where's the wife?" This, of course, was a problem, as the marriage license, which merely followed Minnesota's opposite-sex marriage law, had a box for man, groom, and woman wife, the latter of which these two young men didn't check or didn't think they could check. They were denied the license and decided to bring a case in state court. Their claim was that the denial of a marriage license by the state violated their fundamental right to marry under the federal Constitution. They argued that the Supreme Court of the United States established that such a right existed just 3 years earlier, in 1967, in Loving v. Virginia, the canonical Supreme Court case which struck down Virginia's criminal anti-miscegenation statutes on the ground that it violated the fundamental right to marry under the federal Constitution, and also that it constituted an impermissible form of race discrimination under the federal Constitution. The Minnesota Supreme Court, which is a state court of general jurisdiction, can hear state and federal claims alike, rejected their claim. It maintained that the right to marry was fundamental only because of its link to procreation. Because same-sex couples couldn't sexually procreate, at least with each other, it followed that they could be denied the right to marry. Well, these two young men obviously weren't satisfied, so they appealed this case to the United States Supreme Court, which in 1971 dismissed it for, this is sort of a legal term, want of a substantial federal question, a dismissal which, unlike a denial of cert, constituted a ruling on the merits, one which was binding on lower federal courts throughout the nation. Moreover, because the court's dismissal constituted a ruling on the merits, it effectively resolved the federal constitutional question by essentially saying that the federal Constitution didn't protect a fundamental right to marry for same-sex couples who desire to marry. Its dismissal of that case without an opinion therefore laid to rest the federal constitutional case for marriage equality for same-sex couples in the United States. Note, however, that former Solicitor General Ted Olson has recently teamed up with his Bush v. Gore rival, David Boies, to bring a federal constitutional case against California's Proposition 8. Their claim in that case, which they recently filed in federal district court in California, is that Proposition 8 does violate the fundamental right to marry under the federal constitution and does constitute an impermissible form of sexual orientation discrimination under the federal constitution. So I think their hope is that obviously this will make its way back up to the United States Supreme Court. So, back to 1971. Did the Supreme Court's dismissal of the same-sex marriage question in 1971 mean that plaintiffs in marriage equality cases were out of luck? Of course not. A fundamental tenet of our system of federalism here in the United States is that the federal constitution is a floor, not a ceiling, which means that state constitutions can give more, just not less, protection than the federal constitution requires. So, plaintiffs in marriage equality cases turn to state constitutions in their push for marriage equality. In 1993, so now we're talking about more than 20 years later, two women argued that Hawaii's opposite-sex marriage definition constituted an impermissible form of sex discrimination under the Hawaii Constitution. Their claim was that telling two women, or two men, but it was two women who brought the case, two women they couldn't get married amounted to sex discrimination because but for the sex of one of the women, the couple could marry. It was a very easy sex discrimination claim. The Hawaii Supreme Court agreed, but the people of Hawaii quickly amended their constitution to effectively prohibit marriage for same-sex couples in that state. The Hawaii case is fascinating, though, because it is the only time that a high court of a state found that same-sex marriage prohibitions, like the one that was at issue in that case, were presumptively unconstitutional as a form of sex discrimination rather than sexual orientation discrimination. Since Hawaii in 1993, a number of state courts have considered and ruled on the constitutionality of exclusionary marriage laws under those respective states or under their respective state constitutions. Massachusetts, of course, was the first state to judicially mandate marriage equality in 2003, when the Supreme Judicial Court of that state found that the Commonwealth's opposite-sex marriage definition violated the state constitution. Not all state high courts, however, have followed in the footsteps of Massachusetts. Indeed, most have not. Plaintiffs have made a number of interesting legal constitutional arguments in these state cases, variously arguing that exclusionary marriage laws violate same-sex couples' fundamental right to marry under their state constitution, that exclusionary marriage laws constitute an impermissible form of both sex and sexual orientation discrimination under their respective state constitutions, and even that the right to free expression guaranteed by the First Amendment of the federal constitution and by analogous provisions in state constitutions, that exclusionary marriage laws violate the First Amendment and analogous provisions in state constitutions. According to the latter argument, the First Amendment argument, or free expression argument, which I personally find very interesting, marriage is a form of expression entitled to robust constitutional protection, no less than flag burning and other forms of political protest are. And indeed, marriage is equally incendiary, right, as is flag burning. So, flag burning is protected under the First Amendment, then marriage should be. So as mentioned, in most of these cases, right, we all know plaintiffs have lost, with some state courts insisting, as did the Minnesota Supreme Court in 1971, that marriage is all about procreation, and that because same-sex couples cannot sexually procreate with each other, they can be denied the ability to marry or the right to marry. And with other state courts, like that of New York in 2006, and this argument's becoming much more popular with the courts, maintaining that same-sex couples don't need marriage because when they procreate too well. Under this view, marriage is about, or this view or conception of marriage is about encouraging responsible, controlled procreation, and about cleaning up the mess that heterosexuals make sometimes when they procreate out of wedlock and produce non-marital children. Same-sex couples, again, to continue with this argument, procreate responsibly because, well, they can never have a child by mistake, right? At least with each other. Since marriage was created for those who accidentally procreate, the argument goes, same-sex couples don't need marriage. They're better than it. Under this view, they're better than marriage because they're so-called super procreators.